Welcome, everyone. My name is Jennifer Peck. I'm a partner at the law firm of Solomon, Steiner Peck. I appreciate your attending today. I have to tell you, this is my first webinar, so I will do my best not to do anything that stops the webinar, and also to make sure that I'm sharing my screen. So hopefully everyone can hear well. I've been practicing for over 25 years, and I only practice in the area of estate planning. There's been a lot of changes in the world, as you all know, since 1993 when I first started practicing. The primary focus of my law firm is estate planning. We deal with everything from Medicaid-based estate planning, where we're trying to prevent spouses from becoming destitute when one spouse enters a nursing home, all the way up to helping clients with estates in excess of $11 million reduce the estate tax impact. Today's topic, though, is really near and dear to me because I strongly believe that a person's final wishes should be respected. So I'm going to give you some background and important tips today. But at the end of the day, there is, like most things, no one size fits all. So I am going to be sharing this PowerPoint outline with you. And if you have any questions, please type them into the Q&A section, and I will either answer them while we go along or wait until the end if that makes more sense at the time. And I'm also going to try to prove to you that you can teach an old dog new tricks by me actually being able to use this webinar. So I'm sure you've all heard the old adage, where there's a will, there's a way. Sometimes in our office, we have a slightly different saying, where there's a will, there's a family fighting over it. In Ohio, for a will to be valid, it must be in writing and signed at the end by the testator, that's the person who's setting up the will, in the conscious presence of two or more competent witnesses. Sometimes the court has softened these requirements. I wanted to talk to you about the case of Shaffer, which was a dueling wills cases. Joe was married, and Joe Shaffer was married and created a will in 1967 that left everything to his first wife. And if she was deceased, everything would pass to his children. This is pretty common to say, I'm going to leave something to X, and if they're deceased, I'm going to leave it to Y. Joe's wife predeceased him, so according to his will, that means everything would pass to his children. Years later, Joe met Julie, with whom he had a long-term relationship, and he referred to her as his meaningful other. When he had a health scare in 2006, he asked for a piece of paper, and he actually got just a postcard-sized paper, and he signed what was supposed to be a new will, and he called it a will, leaving a quarter of his estate to Julie, and he wrote for taking care of him. No one signed as a witness, but since Julie was so close to him, she was there when he signed it, and so was her son, who he also had become very close to. They were witnesses. Joe died, and what do you think happened? Well, there were two wills that were attempted to be probated. The probate court ruled that the 2006 will did not comply with the requirements to make a will. And even though they didn't even admit it to probate court, the court invalidated the gift to Julie since she was acting as an interested witness. The Court of Appeals reversed the decision and found the 2006 will could be admitted under the harmless error rule, essentially relying on a factual determination of whether Joe intended to create a will. So Julie won, right? Well, we don't know yet. The Ohio Supreme Court has heard arguments but has not issued a ruling yet. To me, this case is very interesting, but you know what I think? I think that you never want to be in this situation. Joe died in 2015, and his heirs are still waiting for the Supreme Court of Ohio's ruling. That's exactly what we want to talk about avoiding today. So I hope none of our attendees are named Joe, because I would like to say that we don't want to be like Joe in this instance. So I do have a question. Can you have a person, one individually, be the only trustee of a trust and have a successor trustee, possibly a trust company, if that first person passes? Yes, you can. You can appoint as many successors as you think are appropriate for an executor or for a trust role as trustee. So, like I said, a will to be valid must be in writing and signed by the testator in the conscious presence of two or more witnesses. When you're planning your estate, because we're trying not to be like Joe, you want to make sure you do things by the book. And there are 4 rules I always like to follow, and then there's 3 additional rules of thumb that we can use in the right circumstances. So my rules of thumb are basically this. The first one is advanced planning. Whoops. And so what we want to do is we don't want to write deathbed wills or trusts if we can avoid it. We want to make sure that we do things in advance so that they're well thought out and there's less of a chance for someone to challenge them. Now, we do have to do things from time to time at the last minute. Joe had that health emergency and he wrote down his intentions. And so if he had died in 2006, maybe we could have understood why he did it so rapidly. But he lived for 9 more years and didn't make changes to that. And he could have, he had the time to do so. So instead of rushing, if I have the time when I'm planning, I like to sit down with someone, talk about what their needs are and wishes are, send out drafts of documents so that they have time to review them, so they have time to ask questions, meet and go over it. The point here is to show that the person who is making this will isn't being rushed, that they're not under undue influence. They've had a chance to look at the documents. There was intention to the plan. And this also can avoid an undue influence challenge or even a challenge that somehow you've made a mistake on your estate plan. When someone is writing out an heir in particular or leaving more to another heir, I always ask why. That's kind of the explanation, the why and the who you're leaving out. I'm not trying to be nosy, but rather I want to make sure that my notes properly reflect the person knew what they were doing and it was intentional. Let's suppose, to kind of bring this to life, let's suppose Janice has 2 daughters. She loves them both, but one daughter has fallen on hard times and Janice feels she needs to help her more. Having a written explanation in my notes is helpful to me so that when Janice dies, I can talk to her other daughter and explain what Janice's wishes were. What's even better than someone else writing down notes is Janice talking to her daughters before she dies. Hearing it from the horse's mouth can alleviate a surprise at the end. Oftentimes, when people hear it from their family member, they tend to believe it more. No matter how old someone is, mom said or dad said is still powerful. I have found people in their 60s and 70s saying to me, well, mom said. And so those things can be very powerful, and in the right situation, making sure that explanation is not just maybe on paper, but also verbalized to the beneficiaries or the potential beneficiaries can be very powerful in helping to stop a will challenge. What else? Well, if we learned from Joe, we want disinterested witnesses. What that means is people who aren't beneficiaries and preferably not related to you or to a beneficiary. When you're trying to bulletproof a plan, we're not trying to get creative with arguments about who can witness. We want someone unrelated to the testator who is not a beneficiary and is not remotely related to a beneficiary. That is the best, because if we're worried about someone challenging something and we want our wishes to be upheld, we want those disinterested witnesses. Another thing that comes up is also the formality in the execution of the documents. In other words, I want everyone, the testator, the witnesses, in the same room at the same time, signing the documents then and there. So what I don't want is some sort of an argument that, well, I saw the testator sign on Tuesday and you saw the testator sign on Wednesday. We want it to be a very formal occasion so that not only can someone ask questions, but also we can make sure that we know the witnesses were on the same page as the testator and they saw him or her sign and verbalize in some manner that this was their last will and testament, because we're trying to make sure that their wishes are followed upon their death. That's a very important point, is to make sure that we have that formality. What I don't want is I don't want extraneous people in the room when someone is executing documents, if possible. If a person can't drive themselves to the meeting, then that's fine that someone drives them, but those people should wait outside. We don't want to have to argue undue influence. And preferably, before the signing, we want to talk to the testator and ask them questions so that they know what they're signing. Do they know how many children they have or who their next of kin is? Do they know what they own? In other words, that they don't own the Brooklyn Bridge. These are all very important to upholding the validity of a will. So in other words, my witnesses are going to hear not just the testator say, yes, this is my last will and testament and I'm signing it, but rather reiterate that they know what they're doing, that they know that they're married or they're not married, that they know that they have children and how many children that they have, that they know they own a house and a car, and that they have some bank accounts, so that we know that they are understanding the process and what is going on, so that we have not only a disinterested witness, but a witness who could also testify, if necessary, that the testator knew what was going on and what they were doing. So those are my 4 items that I always want to strive for. The advanced planning, if possible, an explanation of the why, especially if you're leaving someone out, disinterested witnesses, and formality in the execution of the documents. So before I move on, I will open it up in case somebody wants to ask a question. Okay, I don't see any questions right now. So the next 3 are things that I might want. And so what they are a doctor's notes. So let's talk about that. What we're thinking of with the doctor's notes is if someone is going to argue that mom was incapacitated when she signed the will, then having doctor's notes showing that she wasn't can be helpful, because it may be that she signs the will in 2006 and passes away in 2020 and has dementia in 2020. Her 2006 will may be perfectly valid if she didn't have any type of dementia then and was competent at the time. So what we don't want is to try to have to recreate things after the fact. So in some instances, it can be very helpful to have doctor's notes of someone's medical health, especially their cognitive health at the time they're executing these documents. Why wouldn't we do this in all instances? Because this can backfire. Sometimes somebody doesn't visit the doctor that much, and the doctor might not be that familiar with the situation. Other times it can backfire because someone may not be able to have that short-term recall, and so maybe the doctor is concerned that they shouldn't be living at home because they might forget to turn off the stove. But at the same time, they may still, even though they have those issues, be able to validly execute a will if they know who they are, the business that they're about, what assets they own, and who their next of kin is. So the idea is that just because someone can't handle every function of their life doesn't mean that they don't have that competency. So sometimes a doctor's notes may be actually detrimental if he or she is only seeing them for small visits and not seeing the whole situation. How about videotaping? In certain instances, this can be a great way to show someone's competent in creating a will that shows what they want. Whenever I think of videotaping, though, I always think of some dramatic movie. This doesn't happen that often in our office, and one of the reasons why is because not everybody is good at being videotaped. And what I mean by that is, I'm sure we've all been at a family gathering and someone who brings out the camcorder or the camera, and you have those people who decide they want to hide from it and they're very shy about it. And so they get nervous or flustered. This, of course, would come off terribly if that type of a person who really is uncomfortable in that situation decided to make a videotape and videotape their will. It may really backfire on you because it may show that they look like they don't know what they're doing. And so the idea is that I think that this can be a very powerful tool in the right situation. We want to make sure that we use it for people who are going to feel comfortable answering questions, knowing that they're being videotaped, and knowing that people will be viewing it in the future when they're gone. So those are the 7 things, so to speak, that you can start off with for helping to bulletproof your estate plan. We're planning in advance. We're explaining what we're doing. We're making sure the will is validly executed by having disinterested witnesses. We're doing it very formally. And then we're thinking about the other 3 things, the doctor's notes and the videotape, and finally the interim. So what an interim clause is it basically states that if you challenge my will or trust, you lose the gift that I left you in the will or trust. It's like a carrot and a stick. Not every single state allows interim clauses, but Ohio does. And so it goes something like this. Let's say that you leave little Billy $20,000, but if he challenges the will, he loses his inheritance. If Billy loses the will challenge, he gets nothing. So sometimes people say to me, well, let's do that, but I just want to leave Billy $1. But with an interim clause, if Billy only loses $1, maybe he feels, why not challenge the will? I only lose $1. So let's take a different example. Let's say that Janice is afraid her daughter will challenge the will. So she leaves her daughter $50,000, the one that she thinks doesn't need the money. And let's say her estate is worth $500,000. That includes her house, her life insurance, her bank accounts, her car, maybe a brokerage account. So her daughter in need will get $450,000 and her other daughter will get $50,000. And then Janice puts an interim clause in her will. She thinks when Janice dies, her daughter who's only receiving $50,000 is incensed. She thinks, I always knew Mom liked you better. Then she thinks about challenging the will. But if she does, she better win that challenge, because if she doesn't, she loses even the $50,000. So the trick sometimes with that interim clause is figuring how much money will keep a person from challenging a will. And so, of course, it's going to be dependent on the size of someone's estate. And sometimes, of course, it depends on the person themselves. Sometimes people challenge things even though it may be unreasonable to do so. Going back to the rules of thumb, though, maybe Janice could have done something else. could have written down why she was doing what she was doing in a note to her daughter. And sometimes I have clients who write what we refer to as a love note. So they're parting wishes to their children or their other loved ones, so that they're explaining what they're doing and also can tell them also how they feel about that person. She also could have sat down and talked to her children. Like I said, this often is not done. People tend to keep these things as though they're a secret. But to me, I do think that that is one of the most powerful ways, is to talk it out and let people know ahead of time what you're doing. So let's also hope she planned in advance. This wasn't last minute. So then next thing I want to talk about is that planning in advance. Because when we're planning in advance, sometimes, as they say, the best plans of mice and men. But I have two things that stick out to me. And I'm not trying to say that you have to have an attorney to create an estate plan, but I do think it helps. We have come across some real issues in some estates lately. And what I want to take as an example first is a plan with no residuary clause. What does that mean? Well, let's say I have a house, a bank account, and a car. I really want my daughter to receive my house. So I say in my will, I leave my house to my daughter, Betsy. And then I think, like a lot of people do, oh, my bank account is small and my car isn't worth much, so I just kind of ignore them. So I've left them out of the will. Besides the house, the rest of my estate, or the residuary, has nowhere to go. And what happens to that bequest if I have sold my house prior to my death? Now my will isn't covering any of my assets. So in my will that I'm advanced planning about, I want to make sure that it also makes sense, that it's covering assets that I actually have. Another issue that I find comes up all the time is when my probate avoidance doesn't match my will. So let's talk about this. Let's go back to Janice as our example. She has two daughters, and let's say she very formally signed a will that leaves everything to her two children equally. But one of her daughters, Sally, helps her pay her bills, and it would be so much easier, she thinks, if Sally were on the bank accounts. So she goes to Friendly Bank, who helps make her bank accounts joint with Sally. And then Janice dies. The bank accounts avoid probate. A will only handles probate assets. So what that means is the will doesn't state who gets the bank accounts. And so bank accounts that are joint and survivor, or payable on death, or life insurance that has a beneficiary, or an IRA with a beneficiary, isn't going to pass under someone's will or trust. Only assets that don't have a beneficiary pass under probate, or assets that name the trust pass under a trust. So the idea is that if Janice had a bank account in her sole name and died, that bank account would be split 50-50, because I said her will says 50-50. But because she went to the bank and made it joint and survivor with Sally, because she was trying to make things easier so Sally could handle things for her, then everything in that bank account is going to go to Sally only. And Janice's other daughter will get none of that joint bank account unless Sally decides to share. And so the question is, will she? Does the will help? As to the first question, will she? Who knows? I've seen it go both ways. As to does the will help? Maybe a little if I'm arguing undue influence or mistakes. But again, that goes back to I'm arguing. Instead, if I had that perfectly valid will, in this case, I want my assets to match my will. So overall, we don't just want to plan ahead with formality, but also with cohesion. We don't want to name beneficiaries that undermine all the good work we undertook. I heard of a case recently where the will said 50-50 to the children, and there was a bank account that was joint with one child. Not a big deal at the time because the bank account usually only had a few $1,000s in it. However, right before mom died, she sold her home and put the money in the bank account, what she thought was going to be temporarily. Then she died before she could put it into an account that would pass to both of her children. Now what happens? That's a good question. So we want to make sure that our cohesive plan is cohesive regardless of what happens, that we don't have a situation like the one I was just discussing. We want to make sure that we can have both things match. So someone asked, can assets be left to a trust in a will to avoid probate? So in Ohio, if I create a trust under a will, then that's considered a testamentary trust, and testamentary trusts go through probate. If I leave assets in my will to a trust that was already set up as a separate document that's an inter vivos or a living trust, then that would avoid probate. And so it kind of depends on how that's set up. So a will that creates a trust in it is a testamentary trust that goes through probate, and a trust that is set up as a living trust that is funded during lifetime. So in other words, I say that my bank account perhaps is pay on death to the trust or titled in the name of the trustee of the trust during my lifetime, would avoid probate. Good question. So I'm going to move on to where should we keep our will? Because sometimes people lose their will. Perhaps some people have their will destroyed. If you watch any Agatha Christie or read them, the wills always seem to disappear somehow. But the idea is that we want our will to be safe. And one way we can make sure that it's safe and not tampered with is to deposit the will with the local probate court. So this can be very beneficial in a lot of instances. It's not always for everyone, however. The downside is if you make changes or perhaps even a whole new will and you don't deposit that with the court, will everyone know that you have a new will or a codicil to that will, or will they think the one on deposit is the most recent and not look for another? So there can be that downside to it. Or of course, the downside that you move, and when you die, you're no longer in that county or state of residence, so no one knows your will is there. Another safe place you can leave it is, of course, in we store wills for clients in our safe, and also, of course, you could try to do it in your safe deposit box, but there's always the issue about getting into that box at death and getting that original out of the safe deposit box. So if you're choosing between those, we want to make sure that someone has access to it upon your death. A safe deposit box that has to go through probate is not going to be that helpful in accessing the will. What else can you do to try to bulletproof your estate plan? Well, one of the things that you can do is called a declaration of validity prior to death. So the idea is that you actually are going to court to have the court declare your will valid. But in order to do that, it has to find a couple of things out. But give me one moment. There's another question, I believe. Someone asks if all assets can be titled transfer on death to avoid probate. The moniker is sometimes different depending on the asset. And so some assets, such as bank accounts, are considered pay on death, and that avoids probate. Stocks and bonds and real estate are called transfer on death, and those avoid probate. And then things like life insurance and IRAs can name beneficiaries. And as long as the beneficiary is not the estate, then that avoids probate as well. And so pretty much every asset can be titled to avoid probate. We always want to think our next step down the road, does that make sense to do? Does it make sense for everything to avoid probate? And that's more of an individual question for people. But if we're really worried about our will being challenged when we die, one of the things that we may want to look at is going to court and having the will declared valid prior to death. So what the court is going to do is they'll declare it valid if it finds all of the following: that the will was properly executed, that the testator had capacity, was free from undue influence, was not under any restraint or duress. Also, that the execution of the will was not a result of fraud or any type of a mistake. And then if this happens, if the court declares the will valid, after the testator dies, unless the will has been revoked or modified, the will has full legal effect as the instrument of the disposition of the testator's estate and is going to be admitted to probate. And so this also can be done now with trusts. So the trust also has to meet similar capacity requirements. We want to make sure that the trust is signed and valid under Ohio law, that this testator has the capacity to sign it, that the execution was not a result of fraud or mistake. And unless the trust is modified or revoked, again, that trust is going to have full legal effect at the creator's death. And so this sounds like it's something everybody should do, right? Well, not in my opinion. And one of the reasons that we might choose not to do this is, for one, is cost. When we go about this, we're actually filing a complaint in the court, and we also have to serve all of the necessary parties. If you're married, you have to serve your spouse. If you have children, you have to serve your children. You have heirs at law who might take intestate, and of course the beneficiaries under the document. You have to take evidence, and later on, if you decide to change it, you probably want to have that codicil or amendment to the trust also proved to be valid. So the idea is this can be a very powerful tool, but I think that it definitely needs to be used in the right instances. So before I move on, I want to just talk about avoiding probate just briefly, because I don't want to make it seem as though that's just the thing to do in all instances. Sometimes avoiding probate can work very well, and other times it can be an issue. And one of the reasons it can be an issue from time to time, if I just go to the bank or the company holding my shares of stock or what I have, and I don't take care of the rest of my estate plan and think about the will, that residuary clause, or a trust that also can have a residue clause, then I might not be handling everything. Let's go back to Janice for just a second. Let's say that Janice has a bank account and that's all she has, and she wants to leave it to her daughter, Sally. And so she goes to the bank and she makes it pay on death to Sally. And that's all. When Janice dies, if Sally survives her, then it will pass to Sally without probate. But what if Sally doesn't survive her? If Janice hasn't taken care of the rest of her estate plan, like we were talking about, that advanced planning, then that pay on death is going to fail, because now we're going to have to go through probate And if she hasn't bothered to do a will because she thought, well, I'm avoiding probate, I don't have to bother with this, then we can have a big mess perhaps. And so the idea is that when someone's avoiding probate, they want to make sure that still they're following all these ideas for making sure that their estate passes in an appropriate manner and that they take the time to do the formalities, whether they do a will or a trust or probate avoidance with a will or a trust. So I wanna move on because to me, when we're bulletproofing our estate plan, it really isn't just about what happens at death, because we're trying to make sure that we're covering all sorts of different areas. And so what I like to think about is something called the core four. And actually, I was talking to my daughter about this last night because she came in last summer and helped out with some of the files and learned a little bit about estate planning. And so I asked her, do you know what the core four are? And she got 3 out of 4, so I gave her an A for effort. But the idea is that we've been talking about what happens at death. And certainly that's the first core part of the core four, and that is your last will and testament. Because like I said, even if I have instances where I've decided to make things avoid probate, sometimes I need to have that fallback. So for example, a transfer on death affidavit isn't valid for real estate unless it's recorded prior to death. So let's take this instance. Let's say that I didn't do my core four. I just said, I want to make a transfer on death affidavit for my house because I want my house to pass to my children without probate. And so I sign my transfer on death affidavit and then I die. And prior to me dying, the affidavit is not recorded. Well, that means that the affidavit is not valid. And so if I haven't bothered with anything else, like having a last will and testament in place, that's going to be an issue. And so even if I decide to do estate planning where I'm avoiding probate, I always like to have that backup of the last will and testament. I think that that's the basis of everyone's plan, even when they use a trust, is going to be to have that last will and testament. The second is a durable financial power of attorney. So the idea behind this is, let's say that I become incapacitated and can't handle my finances anymore, and I don't have a financial power of attorney. What will happen is my family members or other loved ones may have to go to court to obtain a guardianship. And a guardianship is very different than a power of attorney. With a guardianship, it means that the court has made a formal declaration of incompetency, and then they've appointed someone to be legal guardian who then has to follow all of the court's rules regarding spending money and reporting these expenditures. So the idea is that the court there is trying to make sure that the incompetent person is protected. So that's a good thing. But if I have someone trustworthy and I think, boy, I don't want them to have to go through this formality and constantly be filing with the probate court, then a durable financial power of attorney comes into play. That's why it's one of the core four, because it gives me the authority before I become incapacitated to say, these are the people I trust to handle my bills. And so I said people, and that means that I want to think about not only one person, but perhaps also successor people who can serve. And so that is a very powerful document. A lot of times people ignore them, especially if they're married, because they think, well, I don't have to worry about it. Everything is joint with my spouse. And then I always bring up to them, is your IRA joint with your spouse, or are they just a beneficiary at death? Usually the spouse is going to be only a beneficiary at death. And so if someone becomes incapacitated and their spouse is only the beneficiary at death, they can't reach those assets if that person's still alive but incapacitated. And that's something that a financial power of attorney would help with. Additionally, if I own my house joint and survivor with my spouse and he becomes incapacitated, I can't sell his half of the property without a power of attorney unless I go to court and get myself appointed as his guardian. And so there are many different little instances where even when you do have things joint with someone, you still need to have that financial power of attorney. And again, the bulletproofing is all about having control and making sure your wishes are respected. And so that's why I like people to be able to decide ahead of time who they want in this position. So let's see. Our next of the core four is the healthcare power of attorney. And so this goes hand in hand in some respects with the financial power of attorney. And the idea behind it is that if I become incapacitated, I need someone trustworthy to make my medical decisions. And if I don't have anyone appointed in a healthcare power of attorney and I become incapacitated, then a loved one, family member is going to have to go to court again and become guardian in order to make those decisions. Now, this can become especially strange in a situation like this. Let's go back to Joe for a second. Joe's wife died a long time before he passed away. And he never remarried Julie, but they had a long-term relationship. And I don't know what his relationship was with his children, but it sounds like perhaps maybe there was even some estrangement there because she was the one that he depended on. Now, if someone is not married and has a significant other and becomes ill and does not have a healthcare power of attorney, then the court's first going to turn to family members. They're going to look at those family members, and so our situation, they're going to look at Joe's children and appoint them first as guardian of the person for Joe if he doesn't have a healthcare power of attorney. Sometimes we have a situation where someone trusts one of their children much more than another child, and so they want that person to be a healthcare power of attorney. So one of the reasons this is the core four for people to consider, in my opinion, is because of the fact that it gives you control over who you want to appoint to make those very difficult, sometimes medical decisions. Healthcare powers of attorney might last only during an emergency, or they may last for years if someone unfortunately has an incompetency that lasts for a long period of time. And then my final of the core four to consider is the living will declaration. This is the one that my daughter didn't think about. And so the idea behind the living will declaration is supposed to be a positive, but it's supposed to be about self-determination. It's supposed to be that if I'm incapacitated, I can still ahead of time have made those same decisions that I could have made if I had capacity. So I always think a good way to think about it is like this. When someone is suffering through cancer and treatment, there sometimes comes a time when their physician may say to them, these treatments aren't assisting you anymore, and I suggest we terminate treatment. And that patient has the ability, while they're competent, to say, I agree. I don't want to have that treatment any longer. When we have someone who's incompetent who didn't want that treatment and they don't have a living will, then they haven't made that declaration ahead of time. And there can be issues, especially if they do have a healthcare power of attorney. Let's say that Janice has decided to appoint her daughter Sally as her health care agent. That's what it's called, the agent to make health decisions. And let's say that it was very important to Janice that she not be kept alive artificially on artificial nutrition and hydration, and she didn't want all sorts of extensive treatment if there was no hope. Sally can't bear the thought of something happening to Janice, and so using the healthcare power of attorney, she decides to substitute her own judgment for Janice's and decides, let's do it, let's do everything possible. And so even though it was determined to be medically unhelpful to do these things, Janice can't talk anymore for herself, and she hasn't made this predetermination with a living will. So in that instance, it would probably be very beneficial to Janice to have spoken out ahead of time and said in her declaration, here's the type of care I don't want if I medically meet these definitions. And so that can be a very powerful document. It actually will trump the healthcare power of attorney. And so not everyone wants one, not everyone needs one, but it can be a very helpful document to consider and is definitely in my core 4. So I want to just wrap up a little bit. The biggest thing to me is that there isn't one size fits all. We all have different wants and needs. We have different issues and families. We have different assets, and we have different things that we need to control or help with when we're not around or when we're ill. So what is important is making sure that to the greatest extent possible, we have our wishes respected when the time comes, and that we reduce, if possible, family fights. When people ask me if these documents they've signed will prevent family fights, I always tell them that they help to prevent family fights. Unfortunately, there are situations where you're going to have someone who makes a challenge or a stink. It doesn't necessarily mean they win, but they can do that because it is a piece of paper. And ultimately, someone can try to challenge it. So what you want is to have it as bulletproof as possible so that if someone does challenge it, then they see what they're up against, that it's been adequately executed, that it's been well thought out, that we tested for competency, that we have the document, that it's safe, that we don't have assets passing outside of probate that are different than the assets are passing under the will or trust document. So all of these things combined are very important to have. One more question. Okay. Does the executor or power of attorney need to live in the same state? The power of attorney does not need to live in the same state, and oftentimes if the executor is related to you, then the court will appoint them as the executor. It's possible that they may ask them to post bond, however, if they're out of state. Let's see, I have another question. What happens to the durable financial power of attorney when a person dies? When someone passes away, the durable financial power of attorney dies with them. I recently just actually had this question asked to me. A client had wanted to pay mom's bills. She had passed away, and he said, well, I still have her power of attorney. And I said, well, you're going to have to wait to pay those bills because the power of attorney isn't valid anymore now that mom has passed away. So those are all great questions. So, I apologize. I didn't go through all of my slides here, but what I was going to indicate is that if you would like a copy of my PowerPoint presentation, you are more than welcome to call our office at 216-765-0123 and ask to be emailed a copy of it, or you can email me and ask for a copy to be emailed to you. I would like to thank you all for attending, and there is one more question. Can you pay the bills if you have a joint bank account? And so that's a great question. Yes, you can. You can pay bills if you have a joint bank account. So sometimes it does make sense to have that joint bank account. I had used an example where it became an issue because of death, but that doesn't mean that it always is a one-size-fits-all. It can make sense to have that joint bank account for that ease of paying bills, and also for sometimes the ease of paying bills when someone passes away, so that they have the ability to access those funds immediately. And so I do invite you, if you're interested, to consider attending any of our other webinars that we've been doing. I'm hopeful that we can do these in person in the near future, but we'll see what happens. I'm going to be emailing you out an evaluation about this seminar, and ask that you let us know what we have done right or what we could do better about it, or even any other issues that you'd like to see us talk about. And I'm also going to email you a gift for attending. It's a planning guide that we call Moving Forward. And so it's a handy way of collecting information that's very important for a healthcare power of attorney, an executor, a trustee, or a financial power of attorney to have access to. And so I'll stick around for a few minutes if people are still going to pose questions, but thank you so much for attending. And so then I do have another question. Is your firm meeting clients in person? We are encouraging people to use Zoom calls, but we are meeting people in person. We've set up a protocol so that we only have a limited number of people in our office at the appropriate time. And also we do have lots of hand sanitizer, and we have been wearing masks. I actually have, one of my many masks handy here. So yes, if we find that it's more appropriate to meet in person and someone is comfortable with that, we will meet with someone in person. So someone asked, can the residuary clause be drafted to take account of POD or TODs of unknown value? I'm afraid I'm not entirely sure what that means. So I'll try to answer it, and if you want to have a follow-up questions, please do. And so the idea is the residuary clause is only going to be applicable to assets that pass through probate, or if we're talking about a residue in my trust, it's only going to handle trust accounts or things that pay on death to the trust. So if I have a bank account that's pay on death to my friend Bill, then my will is not going to handle that asset if Bill survives me. It would only handle that asset if Bill predeceased me and it had no beneficiary. And so hopefully that answers your question. Because at that time, it doesn't really matter at passing what value that asset is. It just matters whether it goes through probate or whether it passes by contract with the pay on death account. Okay. Well, it's so sunny outside, and I do appreciate everyone's attendance. And I look forward to hosting more webinars. I hope everyone has a great day, and thank you so much. Bye-bye.